Okay, good. So we're going to have two presentations in a row and then some time for discussion. The floor will be first for Chiara Sartoris, who is a postdoctoral researcher at the University of Florence. Welcome, Chiara. And you have about 20 minutes to talk about unfair contractual terms and the consequences for B2C agreements. Do you have a presentation to share with us?
No, I don't have it.
You don't? Okay, then please go ahead.
Good afternoon, and thank you, Professor Mack, and thank Professor De Franceschi and the other professor for having organized this interesting conference. So my presentation has the purpose to examine some new interpretative issues in matter of unfair contract terms and their consequences. In particular, I would like to reflect upon the judicial power over B2C contract with reference to the case of annulment of a core term. So, first of all, what is a core term? It's necessary to start with a general consideration. Despite of the appearances, contract terms are not all the same, but they can have a different relevance within each single contract. Some terms are certainly more important than others because they concern a core aspect of a contract on the basis of an objective criterion. Think, for instance, to a term related to the definition of the main subject matter of the contract, or to the adequacy of the price of the goods or service offered by the trader, when such a term is written in a non-plain or unintelligible language according to Article 4 of the Directive on Unfair Contract Terms. Moreover, think to a term which concern the rate of exchange of the currency with reference to a loan agreement. So the described terms certainly are not ancillary with reference to the logic of the contract. Thus, their eventual unfairness is bound to produce relevant consequences for the consumer. So the question is, in case of annulment of a core term, what is the destiny of the contract? Is it intended to be invalid entirely, or may it be adjusted by the judge to prevent the risk of the total invalidity? The point is that the Article 6 of the directive provide no indications in that regard. Judges only have the power to exclude the application of the unfair term. So what is the approach of the Court of Justice in this critical hypothesis? The Court of Justice has highlighted in the last few years that the annulment of a core term is likely to affect the contract entirely, leading to its total invalidity, because without such a term, the contract is not capable to realize its function and the parties' interests. So it is clear that in such situation might expose the consumer to particularly unfavorable consequences, since the consumer risks not only to lose the good or the service needed, but she or he has also to return what have received so far. Therefore, in this case, the remedy, the total annulment of the contract, seems to be worse than the disease, the unfairness of the term. Moreover, there is another problem, because the dissuasive effect resulting from the annulment of the contract could be well jeopardized. That's why the Court of Justice from the Kassler case of 2014 forward has tried to overcome its traditional interpretative approach aimed at preventing judicial power of adjusting the contract. And in 2014, as it was previously said, the Court of Justice has recognized the judge's power to replace the unfair term with a supplementary provision under national law. However, even if the Kassler case is a fundamental precedent, problems are far from over. Let's think about what's happened if there are no supplementary provisions that may replace the unfair terms. With reference to this very last problem, I would like to reflect upon a recent judgment of the Court of Justice of 2012, which represents just an interesting example of the European case law tendency to strengthen the effectivity of the enforcement against unfair terms in B2C contracts. Let me remind you that the case concerned a credit agreement relating to the grant of a personal loan secured by a first-ranking mortgage. The main interpretative issues regard the fairness, the unfairness of a term which gives the bank the right to control the variable interest rate adjustment mechanism without specifying the consequences. So the Court of Justice is asked by the Romanian judges to clarify which are the national judges' power on the agreement, and in particular, if they may modify the agreement, imposing a method for calculating the variable rate of interest on the basis of transparent benchmarks, or by imposing a fixed rate of interest. So after recalling the rules of Article 6 of the directive, the Court of Justice envisages an exception to this rule. Such an exception concerns the peculiar case in which the contract is intended to be invalid entirely after the removal of the core unfair term. In the case under the exam, however, the problem is even more tough because there is no supplementary provision under national law that may replace the unfair term. So the Court of Justice stages an interpretative solution reflecting upon the rationale of the directive. The court says that judges must ensure the equality between parties, as well as an effective protection for consumers on the one hand, and that the seller or supplier should be deterred from including unfair terms in contracts on the other hand. And in this perspective, the Court of Justice provides that judges must take all the measures necessary to protect the consumers from the particularly unfavorable consequences which could result from the annulment of the loan agreement. And the solution, as it was previously said, the solution is that the judge can invite the parties to negotiate the locking term. So, with reference to the credit agreement under exam, this means that the parties can negotiate with the specific aim of establishing the method for calculating the interest rate. So this decision, in my opinion, is quite interesting because in the light of the Kassler case law, the Court of Justice seems to provide a sort of system of graduation of the effects of the unfairness statements. And this system seems to have a specific goal. It aims at ensuring the preservation and the sustainability of the B2C contracts. So, at the ground zero of this system, we have the simplest cases. So, in some cases, the goal of an effective and dissuasive enforcement can be achieved by the simple non-application of the unfair term, so that it doesn't produce a binding effect for consumers. So if a term is not essential, if an unfair term is not essential, the consumer cannot choose for the remedy of the total invalidity of the contract, but the contract will be partially annulled. In other cases, however, the contract may not continue to exist without this specific term, with the consequent risk to be completely annulled. Such a risk may go to the detriment of the consumer's interests, in contrast with the principle of effectivity. Thus, in these peculiar cases, the core unfair term can be replaced with the supplementary provision of the national laws. And finally, we are at the top floor of this system. And there is the case which has been considered by the recent judgment of the Court of Justice. And the above-mentioned judgment provides an innovative aspect. It takes into consideration the tricky hypothesis where there are no supplementary provisions of a national law to replace the unfair term. So in such peculiar cases, judges can invite parties to negotiate the term with the aim of establishing an effective balance between rights and obligations of the parties of the contract. Negotiation, however, must take place under the respect of two conditions. The first one, it must take place in accordance with the framework set out by the judge. And the second one, it must seek to establish an effective balance between the parties' rights and obligations. So, what are the conclusions of my presentation? In my opinion, the described judgment offers the occasion to reflect upon the relevance of the Court of Justice principles for consumer law of the member states. In particular, in the light of the principle of effectivity, contract invalidity cannot be considered an automatic and necessary consequence of the annulment of a core unfair term. But total annulment should be considered an extrema ratio. On the contrary, partial annulment, together with a contract integration, is a binomial suitable to preserve the agreement with a new fair balance between parties. So by this path, it can be reached the goal of a sustainable discipline for B2C contracts. But what are the pros and cons of the described interpretative solution? This solution is, in my opinion, is of particular interest for two positive aspects. The first one, the negotiation tool offers the consumer the conditions to regain her or his contractual freedom and to exercise it in order to achieve a fair agreement. And the second one, national judges have acquired in the last few years a role which is even more crucial than in the past. It's true that judges cannot make themselves the rule suitable to integrate the contract, to fill the gap, But judges have a different task, have the task to guarantee during the trial the confrontation between traders and consumers with a double purpose, either to promote an informed participation of the consumer to the destiny of the contract, or to ensure the proper course of negotiation on the new contract term. With reference to the cons of such a solution, I think that it's necessary to reflect on the consequences in case negotiation fails or business or the traders tend to prevail again over the consumer during the negotiation. With reference to the Italian system, for example, we have to consider that there is no general rule on negotiation duties. And this, for example, raises the problem if judges have the power to force the parties to reach a new agreement, or if you have the power to create the rule to fill the gap. Last but not least, the risk is again that each member state adopt different solutions to overcome the problem of the unfairness of a core term. And this could go to the detriment of the goal of harmonization of the consumer law within the European market. So in conclusion, I believe that it's important to continue to reflect upon the evolution of judges' power on B2C contracts in order to strengthen the goal of a sustainable protection for consumers. Thank you for your attention.
Thank you, Chiara, and I think you receive a virtual applause from our audience. I asked you beforehand whether you had a presentation, but you didn't need it. I think your spoken presentation was extremely clear, and you gave us some food for thought for the discussion that follows after the next presentation. So we move then to Elina Asimakopoulou, who will talk about unfair terms in consumer contracts and specifically looking at enforcement proceedings from the Greek perspective. And Elina is a practicing lawyer who is affiliated with the Universities of Cyprus and Thessaloniki, and who is also an active publisher in the field of consumer law. So welcome, Elina, and we look forward to hearing your presentation. Do you have a PowerPoint? Or?
No, it's spoken only.
Wonderful. Okay, well, the floor is all yours.
Okay. Thank you very much, Professor Mack, and thank you all for my presence here. It's a great pleasure for me. Actually, the title of my speech could be The Procedural Consumer Protection. I heard with great attention previous speeches and special remarks on this field, and I could say that the central issue of my speech is the pure procedural framework for checking the unfair term of a consumer contract under the light of European consumer law, whose main goal is the consumer's protection as a public community interest, and especially under the light of equivalence and effectiveness, especially connecting it with the adversary and inquisitorial procedural systems. I will also try to make a special reference to Greek procedural law in this European law frame by using European Court of Justice jurisprudence as a primary interpretation tool. It must be noted from the beginning that in Greek procedural law, adversary system and litigants' initiative, meaning that the initiative of invoking facts and allegations belongs exclusively to the parties, prevails totally, without, generally speaking, any differentiation for consumer law disputes. The basis of the thoughts that follow are the co-litigated cases of European Court of Justice with numbers C 693 of 19 and C 831 of 19, on which a decision was issued only on May 17 of 2022. Specifically in this decision, the European Court of Justice held that Article 1 and Article 7 of Council Directive 93/13 on unfair terms in consumer contracts must be interpreted as precluding national legislation, which provides that where an order for payment issued by a court on an application by a creditor and has not been the subject of an objection lodged by the debtor, the court hearing the enforcement proceedings may not, and this is precluded, on the ground that the force of res judicata of that order applies by implication to the validity of those terms, thus excluding any examination of their validity, subsequently review the potential unfairness of the contractual terms on which that order is based. The European Court of Justice jurisprudence on judges ex officio action has already been reached, but I would like to refer to what special we can get from it in a procedural way of speaking. Specifically, the seminal one case, Oceano Gruppo of European Court of Justice, held that effective consumer protection can only be achieved if national court has the power to judge ex officio the unfairness of the term, but based on data or facts brought into consideration before the judge, even only by the plaintiff or only by the defendant. The judge has no initiative to collect the factual material of the trial. In this regard, the adversary system remains unaffected. The basic issue for me lies in the fact that it is not considered necessary to invoke these facts. In other words, the facts are not presented in the procedural form of an allegation. The notable procedural law development at this point could be the following. Submission of trial facts by the party remains totally a prerequisite, but invoking the legal consequence of these facts as a procedural request goes aside. In other words, again, it is not necessary to connect facts with a specific request. The court acts on its own motion, even if the litigant party, in whose favor the legal provisions are stated, does not formulate a relevant request. In Greek jurisprudence, there are very few examples of decisions from which ex officio control of abuse is accepted, and indeed by granting investigative power to the judges. On the contrary, the majority of theory accepts the necessity of this active role of judges. The difficulty actually for Greek procedural law system is the acceptance of a public interest element in these legal disputes, concerning that adversary system in civil procedure is justified exactly on the private interest of the civil disputes. However, the jurisprudence of the European Court of Justice justified this public community interest, community public order, which includes also consumer protection. And this is underlined expressis verbis in case Martin versus EDP editors of European Court of Justice. European Court of Justice underlined that consumer protection is a matter of public interest, and it went further. In case C-137 of 08, it was held that not only the national court must take into account this abuse ex officio, but in the case the court has not the necessary factual and legal evidence to make this judgment, it must also order evidence ex officio. In any case, of course, in this procedural frame, effective judicial protection must be observed from all points of view, as it is guaranteed in Article 47 of the Charter of Fundamental Rights of European Union. Among these requirements is included the right of defense. And what does that could mean for these cases? If the judge, based on the evidence that are presented before him or her, or based on those that are submitted after the conduct that the court ordered, finds that the clause has an unfair nature, an unfair character, the judge must inform the parties and invites them to discuss this according to the formulas of national procedural law, but always under the light of audi alteram partem principle. And this was stated also clearly in a case of European Court of Justice C-511 of 17, Ms. Lindner versus Unicredit Bank, Hungary. The above mentioned, beginning my speech, decision, this latest one, decision of the European Court of Justice, the one issued on co-litigation cases that I referred before, went one, or rather, I could say, several steps further. The court not only examines on its own motion the unfair term, but the requirement to protect European public interest, and this is mean protection of European consumers, forces even the marginalization of res judicata. The res judicata coverage of allegations from the stems from the fact that this belongs to the initiative of the litigant party. The unfairness of a term is an objection. However, in order to ensure the correct and effective application of European law, procedural law should not be left only to the initiative of the party. The judge acquires an active role and has the right to direct the party to invoke the unfairness of the term, even in enforcement proceedings, the last stage of a civil trial, regardless of whether or not this has been proposed at the previous procedural stage, and thus regardless of whether or not this is covered by res judicata. For Greek procedural law, this is a fundamental procedural crack, I could say. According to our provision 933 of Greek Civil Procedural Code, which regulates objections to enforcement proceedings, objections covered by res judicata cannot be proposed at the stage of enforcement under any circumstances, and if proposed, they are rejected as unacceptable. The general question, I think, for domestic procedural law that arises reasonably is the following. The way of adapting the national procedural rights to the requirements of European law and the jurisprudence of European Court of Justice will be left to the judge each time, or it should be regulated for each individual case by legislation. I think the second is practically impossible. What must be understood is that each national judge is primarily a European judge and must constantly bear in mind that the application of national legislation is done using for sure as primary interpretation tool the scope of European legislation and, of course, European jurisprudence. An important jurisprudential example of such an application in Greek data is sporadically found, as I mentioned before. But such an example, I would like to refer the judgment with number 5885 of 2013 of Athens Court of Lower Instance, where it states that Greek judge, against the conduct of the relevant trial on action or objection, when protection of a party debtor as a consumer is requested, even in the case that the alleged claims refer to substantive private law and concern the claim itself and are left, according to Greek civil procedural law, to the power of litigant's disposal, he must carry out an ex officio further allegation, the judge, he must carry out an ex officio further allegation in the sense that it has an official duty to intervene in the gathering of the factual material for the trial by requesting from the consumer party, according to Articles 262 of Greek Civil Procedural Code, and according to 236 of Greek Civil Procedural Code by the objector, to complete the submitted allegation. This was my brief, but I hope lighting speech for procedural law. Thank you very much for your attention, and I'm here for further discussion I'm very interested in. Thank you very much.
Thank you, Elina, and thank you also for a very clear and well-structured presentation. It's a nice compliment to now hear about the procedural aspects of the unfair terms assessment. And I think that goes very well together with the substantive aspects that Chiara highlighted in her presentation. Now, I would like to open the floor for questions of our participants. If you have a question, please raise your hand or switch on your camera. Charlotte Pavillon.
Thank you both for very interesting presentations. I learned a lot. Chiara, I had a question about this new approach to negotiations by consumers. I was wondering, one of the reasons the directive came into being is because consumers are not able to negotiate about contracts and are being imposed terms. And how do you think this would be any different after a term has been deleted from the contract? Is there some momentum, or is it that the trader then really acknowledges the interest of the consumer What would make this situation different from the one wherein the consumer needs protection from the directive? It appears to me that this solution is a bit at odds with the ratio of the directive. So please enlighten me.
Thank you. Thank you very much for your question, because I believe that this is one of the most delicate aspects of this judgment, and I think that the solution of the Court of Justice can arise some doubts. Because from an effective, from the perspective of the principle of effectivity, maybe the negotiation can be the occasion for the trader to abuse of its power again after having prepared the contract. And in fact, the Court of Justice says that the negotiation should be under the control of the judge. So the judge could be the subject able to verify that the trader does not abuse of his or her power. But the problem, I think, it's open, and I think, for example, as I have said, to the case in which the negotiation fails. And also in this case, the consumer risks to remain without an effective protection. And so we have to consider, we have to ask ourselves if judges can force the parties to reach an agreement, or if there is another tool, another contract tool to prevent the risk of a total annulment of the contract. And so I think that this is the point which the Court of Justice, that the Court of Justice has to clarify, because maybe the laws of the member states are not prepared to introduce the negotiation tools, I think, as I have said, to the Italian system.
Thank you for that, Chiara. And I see that Paola Giamisili has a question, and Laura Bacola after that.
Many thanks, Vanessa. And it was just a comment following up to what has been said by Chiara Sartoris now in reply to Charles Pavillon. My question and comment at the same time is, can we be sure that, what has emerged in Banca B from the ruling in Banca B by the Court of Justice can be automatically extended to other national systems, in the sense that I think that what we should be aware of is that in that case, the Court of Justice has concluded that the solution provided by Romanian case law is consistent with the European principle. The court has not said that that approach must be followed or should be followed by other member states. So here we face the usual problem. The fact, to what extent are rulings from the Court of Justice extendable across the board horizontally into other legal systems? I think that what is interesting in the Banca B ruling is the fact that indeed the remedy is not much the negotiation of the parties, because then we fall once again to the question that correctly Charlotte Pavillon was pointing out, but is the fact that judge define a framework. Now, I think that the question, even before asking whether what happens if the parties fail to negotiate, what we should ask is, what is this framework? Is a binding framework? Is a guidance? Is a guideline? And why is this? I mean, even if it is a guideline, why is it different from the guidelines that the same Court of Justice considered in the Lombard case, when there was a consideration of the opinion, non-binding opinion of the Supreme Court of the Hungarian court, that indeed suggested how the contract should be filled in and somehow integrated by the court. In that case, the court concluded that a non-binding opinion was not useful for providing an effective protection of the consumer. In this case, is saying something different. So, I mean, I'm not saying that I think that our approach should not be, okay, then the court is inconsistent. Then, I mean, it's, I think that the effort we should make, and as comparative lawyers, I think this is our responsibility as professors. I think that the effort we should make is to understand the ruling of the Court of Justice in the light of national legislation, because only if we are aware about the specificity of national legal system and contract law, I think that we can better address the question about to what extent a ruling of the Court of Justice may be applied in different systems across the board. And I think this is very enriching, because it is just because the Romanian court referred the court to the Court of Justice that we are speaking about this type of approach and remedy, and we are questioning why, I mean, and whether this is applicable in other legal systems. It is a very enriching dialogue, but we should be very aware about the specificity of different legal systems at the same time. Thank you.
Thank you. And Chiara, would you like to respond to that?
Thank you. Thank you, Professor Iamiceli, for your comment, and I am agree with you. And I have, as I have said, I have many doubts about the effectivity of the negotiation tool. And maybe, as I have said, the judge has a fundamental rule in this negotiation procedure, because as you have said, he states the guideline that the parties have to follow to make the negotiation. And this is so an important role that judges have. But this is a fact that this role, if on the one hand may prevent traders from abusing of their powers, on the other hand, it's a fact that the judges have a more intense power within the B2C contract, because he or she determine the fundamental rules, the framework that the parties have to follow. So it's a power that, yes, it's not the power to create on its own, on his own or her own, the rule to fill the gap, but certainly is a relevant power that should arise some reflections also for national laws. So thank you very much.
Thank you, Chiara. And I think our research question is there for the follow-up for this. But we move to Laura Bacola, who is a PhD candidate at Leiden University. Laura, please go ahead.
Yes, thank you very much, Vanessa. And thank you. It was the presentations were great and enlightening. So thank to both speakers. My question goes to Elena. And I would like to ask you, because I also find it quite problematic that the fact that the ex officio approach is not followed by Greek courts, and I'm also quite familiar with the debate in literature, in Greek legal literature. And I wanted to ask you how you believe, you touched upon this a bit, but how do you think that it would be better to reflect this principle potentially in Greek civil procedural law? Because the way it is right now, and we have this process of everything gets written in the procedure, so you don't really have access, to the judge like in a direct way, and on the enforcement stage, on the other hand, I'm afraid that it might open the floodgates if we say that you can invoke any objection that you didn't invoke in the procedure like before. You can invoke it now in the first place. And at the same time, what I wanted to mention is that there is an aspect, I think, the reason why the Greek judges might be a bit reluctant with the ex officio approach might be the fact that we have this issue with decisions being issued, very, very slowly, like it takes a lot of time, maybe years. And I think what they're trying to do is maybe provide for a speedy, like a quick adjudication. But I totally agree that we should not sacrifice fairness, for being quick in issuing decisions. So yeah, my question is, how could the ex officio approach fit within the Greek civil procedure as it is right now? Thank you.
Thank you. Elina, please go ahead.
First, I would like to say that most of disputes, consumer law disputes, are litigated according to Greek civil procedural law with special jurisdiction, and the procedure is not written, it's oral procedure. So we have the direct communication, the direct communication with the judge, and the judge can rule and direct the parties to complete the allegation. So this is solved in a way. I agree totally with you that if today I was in a Greek conference and I would present this case for cracking res judicata by invoking objections in the enforcement proceedings, nobody could accept it. Even European Court of Justice has ruled in such a way. That's why I characterize this as a procedural crack for Greek civil procedural law. However, I think that when you have a European Court of Justice jurisprudence that rules in this way, as a European judge, you are obliged to follow it. Dogmatically, you are obliged to follow it. We have a supremacy of European law, the scope of European law, and the interpretation of European law and the scope of it is made by European Court of Justice. And as concerning the speediness of the judgments, I think that it's a problem that I could not see how it can be solved. We have many amendments of Greek procedural law. All of these have in the title that the scope of the amendment is to make the procedure more quicker. And I think that we have not done many steps in this field. Unfortunately, we are not the only one in Europe. That's true. It's a common problem, I think. I cannot imagine how this can be solved. Let's imagine that the fairness and the effectiveness and the efficiency is the goal. Thank you. I hope I answered you.
Yes. Okay, wonderful.
Yes, thank you very much. Yeah.
Yes, thank you. And Elina, if I may ask a follow-up question, and I'm not familiar with Greek procedural law, but of course in other member states we see similar questions as to how the courts should deal with the ex officio assessment that the European Court of Justice has prescribed. But that is still in many respects dependent on particular rules of national procedural law in terms of how judges actually work with that ex officio assessment. I think Charlotte Pavillon in her presentation also touched upon some issues in that regard. Now, in the Netherlands, we have a judicial sort of informal committee that writes guidelines, that has written guidelines on how to deal with the ex officio assessment of unfair terms in order to ensure that first instance judges have a grasp of how to do that and to ensure that the application is the same across the entire system. Now, in Greece, how do your judges go about this? Do they also have guidelines, or is it for each judge for themselves to determine how to apply the rules that the Court of Justice has set out?
As far as I know, I'm not sure for this, but I think I'm correct to what I'm going to say. We have no specific guidelines how to apply European Court of Justice. Actually, jurisprudence. Actually, this is a very good idea to say here in Greece, that it could be very, very useful, because let me say that I study the efficient application of European law through national procedural law in many fields: competition law, labor law, consumer law, and the problem is the same to all the fields, that European national judges, and I could say for Greek judges, are not so familiar with the real implementation of European law, how to adapt national legislation to the scope of European law. And to have some guidelines how to apply European Court of Justice and jurisprudence is a very good idea, and thank you for sharing this.
You're welcome. I think it's also probably a Dutch phenomenon to have these codes of conduct or guidelines or standards, they do give us some guidance. Charlotte, would you like to comment on that?
No, I think that there is this guidance document elaborated by the Commission about the directive, but this is a very practical type of guidance. The different steps the court has to take to be able to apply consumer law ex officio.
Yeah, plus it's tailored to
yes,
the national procedural rules.
Exactly.
It might differ from one member state to another. Yes.
Yeah.
Okay.
Of course, let me say that if a national judge is not familiar and is not sure about how to implement, it has the preliminary ruling as a tool for the interpretation of European law. So I think it's a very basic point that the national judges must be educated as European judges.
Yes, and that's you're absolutely right, and that's another very important point where I think we have seen that there are improvements, but there have also been studies that show that there were differences in the level of expertise with EU law amongst national judges. So hopefully the future is bright as we all study EU law in university and the younger generations are much more familiar with European law. Now, I'm just looking at the time. Is there anyone who would like to ask a final question, or one of the speakers who would like to share a final comment or thought? If not, then I would like to thank you very, very much for your presentations, Chiara and Elina.
The pleasure.
I also enjoyed the discussion.
Thank you.
And we will now have a short break until 3:15, and then we continue with the next session on the Volkswagen case, which will also be riveting, I'm sure, Alberto. Okay, well, see you in about 20 minutes then.
Welcome back to our fifth session. We will deal with the Volkswagen case and the equilibrium between consumer and market protection. We are here based on the notes we shared in the previous sessions. We will deal with the crossroads between pre-contractual information duties, rules on unfair commercial practices, and sales law and tort law. So a very challenging, a topic which has a lot of systematic implications, and I'm glad to welcome two distinguished speakers in this session. First of all, Rita Simon from the Czech Academy of Sciences. Rita has a wide experience and knowledge in consumer and competition law, comparative law, public interest. She was already a country rapporteur for the Czech Republic and Hungary in the fitness check of new consumer and marketing law for the European Commission, also for the ex post evaluation of the consumer program 2007-2013, with wide experience in consumer and market law, and now also she developed in the last years specific knowledge in issues regarding social justice and decarbonization, climate change law, and healthy passenger transport. So she is the perfect speaker for opening this session, and I'm glad to give her the floor. Rita, please.
Thank you very much for the kind invitation and for your nice words, Alberto. Happy anniversary for the journal. I'm very happy that the journal exists, and I wish 20 or 110 more years for it. To avoid all inconveniences, may I ask Alberto to share my presentation? That would be very kind. Yes. And the topic today, which I will start and how I learned, Carlos will speak about the Spanish experiences. I will be speaking today, thank you, about the Dieselgate as mass harm activities. I will claim that is permanently enriching our national and European jurisdiction, and what we will show today, they are the second wave of the judgment published by the ECJ, but I will be speaking also or mentioning it that the third wave is already on horizon on the ECJ level, but probably also in the national level. What I will be speaking today is first why Dieselgate scandal is a perfect test case. Then I will summarize shortly the factual background about this trilogy from this summer. And I will pose three main questions. What was questioned from the court referring the decision 145/20, whether the consumer can reasonably expect that an approved vehicle filter complies with the normative sector-specific requirements or not, whether cars with prohibited so-called defeat device systems should be seen as minor lack of conformity, and third, whether some subjective declaration that the purchaser would bought the vehicle even he thought he was aware about the presence of this defeat system would change on the guarantee questions. And I would add some final remarks beyond the contract law. Can I ask for this next time? Thank you. So why Dieselgate scandal is a perfect test case? Because it's first testing the enforceability of consumer sales right in general, the remedies or the limitation period, court jurisdiction was also posed in several cases, assignment of claims. But it also shows the shortcomings of the existing collective redress mechanisms, which we know that the European Commission reacted on that, and we will we have already some new directives. Further, it shows also advantages for countries where the administrative enforcement of consumer law is well developed, because in many cases they have extra remedies what countries where only civil enforcement of consumer law exists do not have. But it's not all. The adequacy of the European vehicle type approval framework was also questioned by these cases, and especially the market surveillance above. I will be speaking about it, that it was not functioning, and I think till today it does not function how it should. And finally, this scandal also showed that the policy approaches which were attempting to achieve cleaner air for whole Europe, but solely through technological improvements, are dissatisfactory. The first wave of the Volkswagen cases reached ECJ in 1918 and 2018, and in 2022 relevant cases were tackled. The first, the French ruling, clarified the admissibility of vehicle switch software system, and the second, the Austrian ruling, made really relevant quote on jurisdiction on national courts. You are probably familiar with the first dispute in the Volkswagen diesel engine. It was a so-called switch software system installed, which actually made the exhaust gas system functioning only in laboratory, but not on the road. So it was practically switched off when normal users use the car on the way. So although this judgment definitely facilitated individual legal actions, the scandal is far from settled. Can we move to the next slide, please? In this summer, 3 cases were ruled by the Court of Justice. Both, interestingly, were referred by Austrian courts, one of the Austrian Supreme Court, the second by the Eisenstadt Regional Court, and the third by the Klagenfurt Regional Court. The first 2 cases, what I wrote on this slide, are somehow follow-on cases from the French ruling, because both were dealing with the permissibility of the follow-on software, which replaced the earlier inadmissible switch software. But the third, which I will be speaking a little bit more in detail in the next 15 minutes, it's very interesting from the consumer law perspective also, because it first time intertwines between the contractual liability of car dealers and sector-specific legislation of vehicle manufacturing. This possibility exists, of course, but it was not settled so clearly by the ECJ as it was made in this summer. And further, this third case answers essential legal questions regarding guarantee, especially on the conformity of goods. The 2 other cases, how I already mentioned, state similarly like the earlier French ruling that software which has, I will be speaking in the next minute about this temperature window, is a not admissible, prohibited defeat device. So if Alberto, you would be so kind that you would move to the next slide, then we will see what are the backgrounds of the case. So in this slide, I tried to summarize everything what's happened before the Austrian Supreme Court referred the question to ECJ. Probably you are familiar with the case, but if not really, then I will just summarize very quickly. An Austrian consumer bought a diesel engine, Euro 5 generation, which contained the originally manipulated switch software, so the first software. In 2015, however, the Dieselgate scandal broke out, and after the decision in US, the General Federal Office of Motor Vehicles, so-called Kraftfahrt-Bundesamt ordered Volkswagen to withdraw this switch system software to re-establish the conformity with the regulation on vehicle approval. How to do it? VW asked the Kraftfahrt-Bundesamt, and actually they received a letter from Kraftfahrt-Bundesamt that a so-called software update would be efficient to re-establish the conformity. But unfortunately, the Kraftfahrt-Bundesamt did not prove in more detail how far this software functions well. So our consumer let to update the software, and he learned about that this software, although functions also on the road, but not all time, because the exhaust gas regulation was fully efficient only in external temperature between 15 and 33 degrees. So if it was colder, like today, the exhaust gas regulation would not function at all. So our consumer filed suit seeking compensation, guarantee for lack of conformity, and annulment of the contract, and secondary compensation against the manufacturer. But he did not win in the first two levels. Both the regional court Linz and also the higher court Linz dismissed the action because they were convinced that the software has no defect, because the Kraftfahrt-Bundesamt has not revoked the type approval. So how you can read the citation? Both courts were convinced that this technique of reducing the exhaust gas recirculation is necessary because it was needed to protect the engine from damage. The Austrian Supreme Court was not satisfied with those decisions, and already noted the decision, the French ruling earlier, so he was asking himself why this defeat system would have a different legal assessment than the other defeat system. And there were also several other questions concerning lack of conformity, and he referred the questions as preliminary ruling because he thought it is not act clear. If you would move to the next slide, Alberto, there is some summary from the Austrian case, where you can read also the three questions, what I was actually mentioning in the introduction, and mainly the first sentence, which I found very interesting and relevant, that the Austrian Supreme Court assumed that the vehicle purchased by the plaintiff was defective, with meaning of the 922 AGBG, because due to the impermissible defeat device, the legal validity of the type approval granted was lacking. So the court actually assessed that although the type approval was not revoked by the authority, the type approval can just not be right because the emission system is just not functioning at 9 degrees or at 35 degrees. And concerning the Austrian average temperature, which is 9.5 degrees, it cannot be that at least half of the year the emission system is not functioning. So therefore they refer these three questions. If you could move, Alberto. Thank you. The first question was connected, what the consumer can reasonably expect, what specialty from the car manufacturer we can actually expect. What are the standards, what the car should fulfill as similar cars should also. The Austrian court was quoting that an average consumer who is reasonably well informed and observant and circumspect should accept that the car is in compliance with the normative requirements. They assume that a commitment to the legal order in this respect must be seen as part of the reasonable expectation of the consumer. The ECJ and also General Advocate Rantos was on the same meaning. They underlined that a vehicle which does not comply with the requirements of this sector-specific regulation does not show quality and performance which are normal in goods of the same type and which the consumer can reasonably expect. So within the Article 2 of the Directive of Sale of Goods, Sale of Consumer Goods was answered. Just a short note, which I found very interesting. General Advocate Rantos is already mentioning the new directive, the 2019-771, and he is speaking about the objective and subjective requirements of the conformity of goods, and he just mentioned that these requirements should fit in the category of the objective requirements. Although the Court of Justice did not take over this part of the argumentation of the General Advocate, the court assumes the same. So regardless of the existence of the type approval, this unlawful use of thermal windows has a strict contractual consequence. So that was the first question. The second question, if you could move, Alberto, please. Thank you. Posed the question of the minor lack of conformity, which had gained two dimensions. It was really important because in the earlier court cases, minor lack of conformity was not explored in detail. There is no case which even Weber and Putz does not show or give us a solution which should be defined as minor lack of conformity. So the ECJ says that the vehicle with this prohibited DVD files cannot be regarded as having a minor lack of conformity. So therefore also secondary or higher level redresses are possible. The second question was, which was really interesting also for the Austrian scholars, in the literature they had a prevailing opinion that when a buyer would assume that he would also make the purchase decision in the knowledge of the defect, that would degrade the lack of conformity only to this minor level. So concerning to some commentaries regarding to paragraph 932(4), sentence 1 of the AGBG, if or consumer would subjectively make a declaration, I would buy the car, although I know about these lacks, it is not that problematic for the case law. However, General Advocate Rantos was really clear against this subjective declaration after the purchasing decision. So in his opinion, he really clarified the consumer should have been informed about this defect in advance before he could do the purchase decision. Otherwise, what he would admit later on does not have any important role, does not play an important role in the legal qualification. So within ECJ decision totally contradicts with the opinion of the Austrian literature mentioned and opened the door for the annulment of the contract. I think we can fully agree with this judgment concerning all three questions. Therefore, further clarification for the contract law are not necessary. Therefore, I would like just make some comments as final analysis on the issues behind the contract law. So, Alberto, please make the last 2 slides. Let's take a view on this picture on the right side. Do you know what is it? It's clear. Can we deal with it? I'm a woman and we do not have car because of sustainability reasons. But if you do not know everything to the small details on the question, then I think you would agree with me that vehicles do not fit in the category of usual or so-called surge goods. Concerning Nelson, who was an economist categorizing the products due to their information content, told that cars belongs probably to the post or experience goods where we know about their quality only after when we used them. For instance, in case of the anti-lock braking system, we will be only confident about the quality after a car had an accident. So lacking personal skills on technical auditability, consumer can only rely on the quality of vehicle components based on granted license or technical controls. Therefore, concerning my view, a flawless performance of duties by authorities, testing facilities, and market surveillance involving the type approval is crucial for the effectiveness of consumer protection. In absence of sufficient market surveillance, civil justice becomes practical and as post-market police force, but how actually earlier scandal showed, for instance, the foreign currency mortgage crisis, that civil courts can alone not ensure that markets function properly. So similarly, as reviewing unfair contract terms in mortgage agreements can only very slowly and inefficiently force financial institutions to responsible lending activities, I would claim that confirming the existence of lack of conformity in purchase contracts can really hard eliminate manufacturers' unfair business practices. So civil law is only plays an ultima ratio role in the ex post control of business market activity. Therefore, I would like to summarize, if you would move to the last slide, Alberto, that the Dieselgate is probably a never-ending story. The third wave of claims are already on the horizon. You probably heard about the Mercedes-Benz claim, which is against a tort law claim. But as long on the micro level, these cases are really greenwashing cases, where the green promise was not fulfilled. On another level, on the micro level, we are really dealing with the quality of the ambient air and consumers' health. So these private law sanctions are not significant when we compare the environmental damage caused by the manufacturer. So in the future, I really count with NGOs' claim, which were claim against market authority because of the inactivities. or failure to monitor exhaust gas level, and for their greenwashing cases. If you take a look on RAPEX, where I cut out these two pictures, since 2016 I found 55 dangerous products in the category of motor vehicles, which have negative impact on the environment. So I think in the future these cases will only grow. With that, I would like to finish, and I hope that this scandal will lead also to improvement of our legal requirements, but also the market surveillance. Thank you for your attention.
Thank you very much, Rita, for your brilliant presentation, which guided us through the different levels of jurisdiction at national and EU level, and which shows how challenging is this issue, and how much systematic perspective we need in order to tackle the problems raised by this case. And for this reason, I'm very glad to now to invite to the floor Carlos Villacorta Salis, who is a practicing lawyer of the Madrid Bar Association and managing partner of BCV Lex Madrid offices. He has a wide experience in defective products litigation, in cases such as the Bal DHL mid-air collision over Lake Constance, then the Flash Airlines accident in Sharm el-Sheikh, and most recently in the Spanair tragedy at Barajas Airport, or the Air France accident on the Atlantic Ocean. So he has the skills and experience from the practicing lawyer side, and will complement the brilliant presentation given by Rita, and I'm therefore glad to give him the floor. He will speak about the Volkswagen case and termination of contract, the Spanish experience. Carlos, you have the floor.
Good afternoon, everybody. Good afternoon, Professor De Franceschi. First thing, I have to express my gratitude to you for inviting me to this wonderful conference composed by a full array of masterminds in consumer law. I am a little bit overwhelmed because I'm just a street court practitioner. So all what I say here today will be filtered by the fact that I am a plaintiff litigator. The fact is that I am not really even a consumer law specialist, because I'm just a personal injury in the cross-border and international field practitioner, especially in aviation accidents, as Professor has just said. I'm going to try to share with you my little presentation, which is here. I don't know if you can see it. Is that okay?
Yes, perfectly.
Perfect. Okay, I will try to give you, from a mostly a chronological point of view, the story of what has happened in Spain so far after 7 years with the Volkswagen Dieselgate case. As all the cases in Spain, such as this one, the case started with the opening of a criminal investigation. The Audiencia Nacional, which is a court that has jurisdiction over the entire territory, has the competence to investigate crimes that has an affectation of all the regions, opened this investigation in October 2015, just 1 month after the scandal appeared was known in the United States. One of the particularities of the criminal investigation in Spain is that civil parties can be a part of the investigation. They can show up. They can ask for investigation measures, and if the case goes to trial and the criminal conviction is awarded, they will be compensated for their civil compensation or civil consequences of the crimes committed. One of the other particularities of the criminal system in Spain is that corporations can commit crimes. Of course, they cannot go to jail, but they can commit crimes specifically mentioned in the criminal code and be subject to fines. This is, of course, an exception of what it still applies in some countries in Europe. Germany is one of them, as far as I know, where the classical Roman principle of societas delinquere non potest is still in force. As we will see later, the criminal investigation lasted for merely 3 years. After these 3 years, the court decided to transfer the investigation to the German prosecutors through the Eurojust criminal cooperation system. But effectively, because of many appeals and recourses filed by the parties, particularly by myself and other lawyers, I am united with to cooperate in the Volkswagen Dieselgate scandal. The case has not been effectively being transferred until 2022. Meanwhile, since 2015, of course, not all of the 700,000 car owners that were affected with the scandal in Spain showed up in the criminal proceeding. Only around 8,000 to 10,000, mostly represented with my law firm and the coalition of law firms I work with in the case. We showed up on behalf of these 8,000 affected cars, but many other individual owners, they decided with their own individual lawyers to file their cases in civil and commercial courts. Most of these actions were actions against the dealers, and just a few against the distributor and or the manufacturer. Different types of actions were exercised, either consumer protection law specific actions such as lack of conformity, of disloyal competition, which is not exactly a consumer protection law action, but it is contained also in the consumer law legislation, but also civil law. Classic civil law actions like nullity of the contract, radical nullity, relative nullity, termination, or even negligence. I have to say here that at least in Spain, I don't know the case in other countries, but at least in Spain, consumer law actions do not supersede civil law actions, which means that the consumer has the choice of deciding which type of action if he has several actions available, he can choose which type of action, either strictly consumer action or civil law action wishes to file. This is something that was confirmed by the Supreme Court in 2020, specifically in one Volkswagen case. Talking about the actions that were filed over these years in civil and commercial courts, probably the most important action that was filed was a disloyal competition action filed by one of the largest consumer associations in Spain, which is OCU. They filed this action on behalf of 7,000 car owners. As you know, disloyal competition requires the concurrence of two different elements. The first is the commission of a behavior which objectively is contrary to the requirements of good faith, and in particular contrary to the professional diligence which is due by the seller, by the dealer. And the second is the commission of acts of deception, the dissemination of false information or information that, even being true, due to its content or presentation, misleads or may mislead recipients, being susceptible to alter their economic behavior. Well, after 3 years of litigation, the Commercial Court Number 1 of Madrid rendered a judgment in January 2021, almost 2 years now, in which the court awarded fully the demands of the consumer association. specifically, the court ordered the publication of the judgment in the national diaries. It also ordered the cessation of all disloyal competition behaviors by action or omission from the seller. And third, and most importantly, the court awarded compensation for damages. The particularity of the compensation for damages in this case is that the court awarded exactly the same compensation for the 7 car owners, with no regard to the value of the car, the mileage, or the year of the purchase contract. The court considered that the damage was a matter of res ipsa loquitur, that was evident that there was a damage, and the court estimated that the damage should be of 3,000 euros for each car owner, divided in 1,500 euros in material damages and another 1,500 euros for non-pecuniary damages, as we would call moral damages. Of course, this judgment has not been enforced because it's in appeal. The appeal is still pending, and no matter which the decision, that the case will surely end in the Supreme Court. The second type of strictly consumer law actions that were filed scattered around the country was lack of conformity, requesting the cancellation of the contract with lack of conformity, because the product sold does not meet or conform the condition of the product as per contract. This action provides for the consumer the possibility of asking for a reduction of the price or the termination of the contract, and in all extent compensation for the damages sustained. All of these actions, as I said, were individual actions filed by the individual car owners in different courts around Spain, have succumbed either in the first instance or the appeal levels. Basically because the courts have been insistently saying that the lack of conformity, if there was any, it was of minor importance. The minor importance, and in addition, it had been subsanated by the seller with the software fix. We have already heard from Rita what's the opinion about these 2 points from the European Court of Justice, and I will mention at the end which is the consequence for the future in Spain. In none of these cases, the termination of the contract was accepted, and in most of the cases, compensation for damages was awarded. But in most of the cases, I would say in all of the cases, material damages were rejected because parties were not able, according to the courts, to demonstrate the existence of a specific material damage, whether it was an increase in maintenance or a reduction of price or increased mileage, etc. In general, the courts have, in different regions, have awarded a compensation of moral damages of 500 euros, who over the years became some kind of standard for the moral damage compensation in the Volkswagen case. Coming back to the other types of actions that were filed, and now entering in the non-consumer law actions, but rather in the civil law actions, I'm simply mentioning here the basically 4 kinds of actions that could have been filed, and actually were filed over the years. The first is radical nullity, which provides requires to demonstrate the existence of the non-concurrence of one of the 3 essential elements of the contract, which are, as you know, consent, object, and cause. The second action is relative nullity action, when there is a vice in one of the elements. The elements are present, but one of the elements is vitiated by one of the defects, which render them invalid according to the law. In example, in this case, a vice of consent would be a vice where it could be demonstrated that the car owner would not have bought the car if he knew that the car was not compliant with emissions standards. The third action is the action for resolution for breach of contract. This action seeks the termination of the contract due to this breach by the seller. in our case, Volkswagen failed to deliver a car compliant with emissions regulations and in addition fitted with an illegal defeat device. The fourth action, which is, I think, residual, and it has not been filed so much in Spain, but that I will mention, it's important to mention it here because it has a consequence in the next slide, as you will see, is the classical Achillean action, non-contractual action based in fault, based in negligence. And this is something I'm going to tell you now, which is very important. It is related to the negligence I was mentioning in the previous slide. Is that one of the several judgments that the Supreme Court has already rendered in Volkswagen is this judgment 735/2020, which creates it is a real novelty for us, which establishes an exception to the principle of relativity of contracts. In this decision, the Supreme Court considers that in the field of manufacture, distribution, and selling of cars, it has to be deemed that effects of the purchase contract between the dealer and the car owner have to be extended to the distributor, and the manufacturer, due to the specific nature of the motor market. This means one simple thing: the action for the termination of the contractual action for termination of contract, that it is available for the consumer against the dealer, which is the party with whom he signed a contract. It's also extended and it's available against the distributor and the manufacturer. That's a novelty in our doctrine. Until now, the Supreme Court had maintained a relatively strict application of the principle of relativity of contracts. And what is important also in this judgment, which also connects with I said before about the fact that consumer law does not supersede civil law, is that the Supreme Court seems to consider that in a case like Volkswagen, Article 1124 of the Civil Code, which is the one that provides termination of contract in case of breach of contract and compensation, is an available and an effective remedy for the car owner, and it's probably shown as the most effective, really. I'm going to explain now the reason why the decision, you will see it very clearly now, why the decision of the Supreme Court is important. And it's important because of the statute of limitations. We have an array and a constellation of different statutes of limitation periods for the different actions, which are resumed here. Disloyal competition is 3 years of prescription. Lack of conformity is 5 years of prescription. Radical nullity, of course, it has no limitation period because it's based in the inexistence of the contract. Relative nullity is 4 years, but in this case is caducity, not prescription. Resolution for not fulfillment is 5 years, and negligence is 1 year. You will see the difference between asking the manufacturer for the resolution for which and compensation for which you have 5 years, and instead asking for damages, only for damages for negligence, for which you have only 1 year. So this way, the Supreme Court has somehow extended the statute of limitations. How did this statute of limitations are applied? I'm going to explain it here very quickly as well. Prescription, prescrizione, péremption in French. I don't know how condition precedent maybe in English or in America at least would be similar to the condition precedent. In Spain, prescription is interpreted in a very restrictive way, always trying to favor the action. This means that prescription can only be awarded upon request of the party. The dies a quo, which is when the clock starts ticking, is not necessarily the day of the illicit by the wrongdoer, but rather the day where the victim or the consumer, the affected, the aggrieved party, can effectively file his action in court. In personal injury in Spain, it is typical that the dies a quo for the prescription limitation period does not start the day of the harm, the day of the illicit act, but rather the day where the victim has recovered or stabilized from from his injuries. In the case of Volkswagen, this means that the dies a quo for the prescription period, any prescription period, would be the day where the scandal appeared, probably in September 2015, and not the day where the car was bought. That could be even in 2008. Another particularity of the prescription is the interruption. When the interruption occurs, the clock is reset back to zero. A letter of claim, it's enough in Spain to interrupt the prescription. I think other countries allowed also letters of claim to interrupt. I think Greece is one of them. Another particularity is that criminal proceedings, which are related to the same facts that are in which the civil actions are based, also interrupt prescription limitation periods. And there is also something very important, is that all civil parties are benefited of the existence of the criminal proceeding in the sense of the interruption of the prescription, whether they are present in the proceeding or not. So all parties, all the 600, this means that all the 700,000 car owners in Spain were benefited of the interruption of the limitation period by the criminal proceeding until the criminal proceeding was transferred to Germany, as explained in this year, 2022, as explained before in a previous slide. The exception to prescription is caducity, which is a much more restrictive limitation period. It can be agreed ex officio by the court. The dies a quo is always the day of the illicit act, the day of the wrongdoing. There is no interruption available other than the filing of the claim in court, suspension is one of the particularities of caducity, which means that if the clock is not brought to zero, but it's rather paused. For example, in the case of Volkswagen, a person who bought his car in 2013, his action, his relative nullity action, which is submitted to a caducity period of 4 years, would be suspended when the criminal proceeding started in October 2015. And now that the criminal case has been transferred to Germany, the caducity time period starts. The clock starts moving again, and there are more or less 2 years remaining to file this action in court. I'm here to recall very very quickly what Rita Simon already explained about the three recent decisions of the European Court of Justice, the three elements which I think are more relevant for consumers. The first is that the new software, the fix, what it's called the fix, that was proposed for Volkswagen to resolve the issues found in the original deceptive software. It is also a defeat device provided by Directive 715/2007, which is simply because of what Rita already explained about the thermal window. This defeat device, what it does is that it deactivates all the emission reduction systems, the EGR valve notably, when the car is operating in temperatures over 33 or below 15 degrees Celsius. But also if the car is being operated over 1,000 meters altitude, the system also deactivates, which means that in most of the cases, in most of the time, no matter where the country you are in Europe, the emission reduction system is actually not functioning. The second consequence, the second conclusion is that the new software implies a lack of conformity in the vehicle sold, as it does not have the quality that the purchasers can reasonably expect. The vehicle must comply with the technical regulations. If not, there is a lack of conformity. And the third, and probably one of the most important conclusions, is the lack of conformity is not of minor importance. And this refers to both original illegal defeat device as well as to the fix software which is also considered as a defeat device, which is the potential consequence, at least in Spain, as the car owner asked for the proper execution of the contract, and this is unsatisfactory, seen as confirmed by the European Court of Justice. The car owner has a free hand to terminate the contract, and it can do so because the lack of conformity is not of little importance. I will now talk during 2 minutes, and I'm finishing, about the first judgment that was rendered in Spain after the European Court of Justice rulings of this July 2022. This is a judgment awarded by a civil court in Alicante in September this year. It was filed by one of the lawyers with which I cooperate in the case. In this case, subsidiary petitions were made in the claim. We filed several test cases in different areas of Spain. This was one of them. Subsidiary petitions, as I was saying, were made in the claim in the following order: radical nullity, relative nullity, termination of contract for breach of contract, and compensation for damages. The court agreed with relative nullity. The court agreed that there is no caducity because, well, as I explained before, the car was bought in 2013 and the caducity period was suspended in 2015 with the criminal proceeding. The court awarded the extinction of the contract, the termination of the contract, the annulment of the contract, which implies a necessarily reimbursement of full price paid and return of car. In this decision, there is no explicit mention to the European Court judgments, although the court implicitly applies its doctrine when considering the improper execution, equivalent to a lack of conformity, as of being of major importance, as substantial enough to justify the relative nullity of the contract. Of course, the judgment is already in appeal. It will certainly be taken by one or others to the Supreme Court, and we still have a long way to go. So now what? The situation in Spain is that nearly 600,000 car owners have not claimed at all, probably more than 600,000. The reality is that they still can do it. They still can ask for the termination of the contract based in the civil code, or lack of conformity based in the Consumers Law Act. Both actions are submitted to a prescription limitation period of 5 years that, in the best of circumstances, in the worst of circumstances for Volkswagen, started in somewhere in June this year, when the criminal court ordered performed the transfer of the criminal investigation to Germany. So therefore, this action will not prescribe at least until 2027. What I think is that given the precedents of the European Court of Justice, and the conclusions in some pending cases, such as the Mercedes case, in which Rantos is suggesting that the directive protects the interest of the consumers, in the sense that it is presumed that there is a presumption that the consumer would not have bought the car if he knew it was not compliant. This opens the door to also to a wave of actions for nullity of contract, and of course termination of contract will be of course available. So there is still a long road to walk, and a long path to walk, especially because of the behavior of Volkswagen, who's refusing any kind of settlement talks with anybody. They only globally settled cases in Germany with the German consumers, and in England, in the UK, in the context of the group action that was filed over there. But in the rest of countries in Europe, to my knowledge, there is no sign or any willing of Volkswagen other than pushing the case forward in courts. So that was my presentation, and I thank you for your attention. Thank you very much.
Thank you very much, Carlos, for this excellent presentation, and which shows how many issues and how many levels, problematic levels, are implied in this case. I particularly liked when you stressed the notion of minor lack of conformity, and then the problem with time limits, which really is a challenging one. Also, in light of the circumstance that the Sale of Goods Directive left up to the member states and the discretionality of member states to determine time limits, and this caused a lot of fragmentation in way of implementation, and also no word about suspension in case of lack of conformity of the prescription and so on. So a lot of food for thoughts. And now I would like to open the floor for questions. So please raise your hand or write in the chat your questions. I see a remark by Elina Azimakopoulou in the chat. Just to confirm, a limitation period in Greece is taking into account only on party request. I think it was mentioned.
Yeah, well, no, this is not. And again, I'm stepping in someone else's garden. Sorry, Elina, but all what I said is that I think that the limitation period in Greece, as in Spain, can be interrupted with an out-of-court letter of claim. Of course, in Greece, as in Spain, the prescription limitation period can only be awarded upon request of the defendant, upon request of the party. It is only in the caducity, special and more exceptional caducity limitation periods where the court can agree it ex officio. So just to clarify.
Thank you. Other remarks or questions? So I might step in for a question and bring the Italian experience in, as I was writing an opinion for the Court of Braunschweig regarding the Italian case. And I see that the discussion in Italy in this regard, as I briefly mentioned before, is very much focusing now on the level of extra-contractual liability, also because of the 2 years prescription for lack of conformity. But it is stressing and it is concentrating in the synergy, on the synergy between the law of unfair commercial practices and the extra-contractual liability. So first of all, based on the assessment by the authority, the Market and Competition Authority, assessing the unfairness, the misleading character of the commercial practice, and therefore assessing a breach of the fundamental right of the consumer to fair practices. And on this basis, the Court of Venice assessed extra-contractual liability based on the general norm of the Italian Civil Code 2043, and the unlawful action should be the violation of the fundamental right of consumer to fair practices. So I wonder whether this synergy between public law proceeding, so administrative law proceeding, and civil court assessment of extra-contractual liability may be a viable solution in order to improve protection at this level, also in other member states.
I don't know if Rita is going to say something. I will just jump to say that what I have seen so far, and this is probably an intoxication of my involvement in personal injury cases all around the world, is that particularly in Europe, despite the fact that we want to have common grounds, and even when you have laws that prescribe, for example, in product liability law you were mentioned at the beginning, that the 1985 directive provides a statute of limitation of 3 years and a statute of repose of 10 years. The problem is that prescription limitation periods are subject to procedural rules and substantial rules in each national country. The 10 years can be 15 in one country and only 3 in other. So there is a lack of uniformity, which provides a certain amount of uncertainty in the context of the European Union as how to implement all these rights and all these actions.
Only one comment. I think it's a nice synergy, but it depends on the activity of the member state authority. So it can diverse. In Italy, we know that the authority is very active and very brave to improve new ways or try new ways to enforce the consumer rights, but in other countries, the authority is not that active. So therefore, I think also civil law enforcement is necessary.
Thank you very much. Other questions or remarks? I see several experts on this topic in the room, but perhaps they would like to have the coffee break, the deserved coffee break at this stage.
If I may, I would just like to know if somehow in Spain the environmental damage has been addressed at public level. Not at all.
Not at all.
And this is also a remark because it's very strange to me that at European level, no one is addressing the environmental damage, not even at two dimension.
I have met with high-level officials in the environmental ministry over the years due to this case, and in all the occasions, I was told that the only reason why there was no administrative proceeding against Volkswagen in order to impose sanctions or take actions of any kind, the only reason why they would not do it is because there was a criminal investigation ongoing. So they had the excuse of the criminal investigation not to do anything. So now we have just sent a letter 2 months ago to the ministry asking them, well, now that we don't have any criminal investigation anymore, are you going to do something? Are you going to open an administrative investigation and eventually sanction Volkswagen for what he did? There are many studies, and well, you know much better than me, and probably Rita knows much better than me, numerous studies that show which was the real impact in the atmosphere of this scam. And we now know that there were many other scams. Rita mentioned Toyota and Renault, and there is also Mercedes, who's in the waiting list in the European Court of Justice in one important case in which Rantos has already filed his conclusions, and that it might also have an effect on the Volkswagen litigation. But unfortunately, no. And the truth is that the society, the people, they don't care much. The reality is that our level of conscience of the importance of these kind of things in the environment are not very high. It's still not very high, despite the fact of what we are seeing every day in the news and what we are seeing through our windows. It's happening. but we are not reacting. So it's a quite bit scary, I have to say.
Thank you. And it is also very strange to me that also from competition law perspective, no competitors of Volkswagen are acting. So there is something strange surrounding the whole case.
There is one simple reason to that, Francesca, is because they are all guilty of the same sin.
You told it.
If I could add one remark concerning the environmental damages, actually many NGOs are trying to deal with these problems, Climate Earth and so on, also the Czech one tried, but they have huge problems with the causality. So courts are very reluctant to say that, okay, this type of car made this emission, you can really measure it. So you cannot measure which car is polluting how much. You cannot make a general statistic, how many cars do you have in the city with dead motors. Therefore, these court cases are always dismissed. This is what the NGOs, environmental NGOs, are really lacking, and they do not have the same collective redresses as consumer protection NGOs. We can see always this problem. The class actions are often open for consumer harms, but they are not open for environmental harms. So therefore, the redress mechanism of environmental NGOs are not on the same level than from consumer protection organization. And many cities are struggling with the ambient air quality plans, what they have. This is air quality problem. However, they just practically cannot do anything against the manufacturers. They can limit the cars to come in the cities or make low emission zones, which do not make sense, because you would think that the Euro 5 is a clean car, but we all know that they are not. So therefore, it's a very disputed problem. Thank you.
Thank you.
Thank you very much for this challenging and thought-provoking session, which delivered very good food for thoughts. And I'm very thankful to Rita, Carlos, and those who took part in the discussion. And so thank you again. And now we will have a break. I would say we will resume at 4:30 for the last 2 days session. Thank you, and see you in a couple of minutes. So welcome back to our 6th session, the last session for today, on product liability and consumer law. Unfortunately, Geraint Howells is not able to join us because of a last-minute issue. He apologizes for that. We will miss him as one of the leading scholars worldwide for product liability, but he will hopefully join us tomorrow. And therefore, I have the pleasure, I will not able to replace him given his outstanding knowledge in this sector, but I will try to moderate the session. And therefore, I'm glad to open the floor and welcome Edoardo Ruzzi from the University of Roma Tre. Edoardo is a PhD candidate and teaching assistant at the law department of the Roma Tre University. His main fields of interests are private law, comparative law, and ICT law. He is currently conducting research on the regulation of the data economy, namely B2B transactions involving industrial digital assets in the manufacturing sector. So I am glad to give him the floor, and he will talk about the last decade of product liability case law, how the CJEU shaped the proposal for a new directive. Edoardo, you have the floor.
Thank you, Professor, for your introduction. I'll try to share a few slides. Give me a second, please. Can you see the presentation?
Yes.
Thank you very much.
Yes, perfect.
As mentioned by Professor De Franceschi, at the end of September, the European Commission presented a proposal for a new product liability directive, which is intended to repeal the directive adopted in 1985. And the need for reform of the European product liability regime has been much debated in the last 10 years, particularly the need to update some of its core concepts to reflect the way goods are now manufactured and distributed. And accordingly, the proposal provides extensive changes to the notion of product, which has been expanded to cover software and digital manufacturing files, such as those that are used for 3D printing, or another key concept, that is the concept of damage, which now includes loss or corruption of data. However, in this brief presentation, I'll focus on the new rules set out in Articles 8 and 9 of the proposal, which aim to ease the burden of proving the fundamental elements of liability, particularly the defectiveness of the product and the causal link between damage and defect. The general rule under the current directive is that the person who has suffered harm from a defective product is required to prove the damage, that the product in question was defective, and that this defect caused the harm suffered. And the proposal does not depart from this approach on the burden of proof. However, it introduces different mechanisms to alleviate the burden of proving defectiveness or causation. Article 8, for instance, provides the right of the injured person to obtain, under certain circumstances, relevant evidence from the defendant. A similar rule of disclosure was not present in the directive of 1985, but at the same time, it is not an obligation that was introduced with the proposal for the first time, because in the Novo Nordisk case, the Court of Justice of the European Union had already endorsed a national rule that gave claimants the right to obtain information from the defendant. So starting from this case, in this brief presentation, I would like to assess the influence of the Court of Justice case law on the proposed reform of the EU product liability regime, with a particular focus on the judgments issued in the last 10 years. My argument is that the information right and the evidentiary rules set out in Articles 8 and 9 of the new directive are mostly a mere codification, a restatement of the case law of the Court of Justice of the last decade. In particular, national courts have referred questions on how to apply the directive's rules on the burden of proof 3 times in the last 10 years. These preliminary rulings are Novo Nordisk Pharma case, Boston Scientific Medicine Technique case, and the Sanofi Pasteur case. And I'll argue that this judgment not only played an important role in developing our understanding of the directive rule, but also they had a direct influence on the evolution of the EU product liability law, as the court's considerations are now incorporated into the text of the proposal. And it is worth noting also that the directive of 1985 is formally a market integration instrument adopted under Article 100 of the former treaty establishing the European Economic Community, as its final text was the result of a difficult political compromise between business and consumers' interests. The court's approach in this field of product liability has always involved a complex balancing exercise between these conflicting interests. However, these 3 rulings stand out for taking a more consumer-friendly approach. In fact, the court ratified national evidentiary rules that made easier for claimants to provide evidence in complex cases involving medical products. And with the subsequent incorporation of these rules in the proposal for a new directive, we may say that the court had a propulsive, a positive approach in promoting consumer protection. Starting from the Novo Nordisk Pharma case, this case originated from an action against a pharmaceutical undertaking under the German special liability regime for medicinal products, which was already enforced at the time when the directive was notified. And after the directive's adoption, a change in the German law introduced the right for an injured person to require the manufacturer of a medicinal product to provide him with information on the adverse effects of that product that was suspected of have caused the damage. And the right of disclosure is intended to make easier for the victim to demonstrate the defect of the product and thus establish liability of the manufacturer. And the dispute reached the Federal Court of Justice, which was uncertain as to whether the new provisions of the German law were compatible with the full harmonizing character of the directive. In his opinion, Advocate General Spooner recognized that in the context of the product liability framework and the strict liability regime laid down in the directive, there is no departure from the general principle of actor incumbiti probatio, as the victim is still required to prove the damage, the defect, and the causal relationship between damage and defect. You notice that this general principle, however, was often tempered in the member states by substantive and procedural rules based on considerations of equity. As long as these mechanisms are aimed at eliminating a significant imbalance which exists between the manufacturer and the consumer, this was coherent with the fair apportionment of risk that was one of the main goals of EU law. So following this view, the court thus held that national legislation may facilitate the injured person in proving the elements of liability, as long as these mechanisms do not lead to a complete reversal of the burden of proof. Article 8 of the proposal builds on this ruling to expand the scope of the victim's right to require the disclosure of relevant evidence from the defendant. And this ruling was limited to the right to obtain information on the adverse effects of pharmaceutical products. On the contrary, the proposal extended this right to obtain disclosure of evidence beyond the boundaries of a single jurisdiction and a given sector of production. So building on the considerations of the Court of Justice, the European Commission took a clear stance in favor of a greater level of protection of consumers. And in the following Boston Scientific Medicine Technique decision, the court was again confronted, as I said, with a dispute concerning defective medical products. And the judgment originated from two actions for damages brought against a manufacturer of a medical equipment that recalled a family of pacemakers after detecting a manufacturing defect that caused premature battery depletion. And the manufacturer offered free of charge replacement devices for patients, depending on that family of product, although it did not compensate for the medical expenses of the surgical operations. However, in this case, the claimant who that was the health insurance provider that was subrogated in the position of two patients, pursued the manufacturer to recover the funds paid for the insured, and he could not provide direct evidence of the specific defect of the two pacemakers implanted in the body of the patients, as they were destroyed immediately after the removal. And since the products were unavailable for inspection, the claim relied on purely circumstantial evidence, namely that the manufacturer's recall of a group of pacemakers for an increased risk of failure was enough proof to maintain that every product of the same family was defective. And the court referred two preliminary questions to the Court of Justice, asking in essence if the claim could be framed within the concepts of defect and damage laid down by the directive. And in a very consumer-friendly decision, the Court of Luxembourg held that where it is found that such products belonging to the same group or forming part of the same production series have a potential defect, it is possible to classify all the products in that group or series as defective without the need to establish that the product in question is defective. Therefore, the ruling has the effect of easing the burden of proving the defectiveness on the part of the injured parties and strengthening their position in product liability litigation. Although the European judges have carefully limited their holding on a specific class of medical products for which the mere possibility of failure is sufficient to meet the defectiveness standard, the decision considerably expanded the scope of European product liability law well beyond also its purely compensatory function. And in the same vein, in the following Sanofi Pasteur, the court was again confronted with the question of the compatibility of national evidentiary rules with the directive's provisions on the burden of proof. And the case involved a man who was vaccinated against hepatitis B and shortly afterwards developed multiple sclerosis. And he subsequently brought a product liability claim before the Regional Court of Nanterre, arguing that the vaccine he received had been defective and had caused him to develop the disorder. And he relied to the case law of the Cour de Cassation regarding liability for defective vaccines, under which proof of the causal link between defect and between defect in the product and the damage can be derived from serious, specific, and consistent presumptions, even if there is no conclusive scientific evidence to the matter. And the question referred to the Court of Justice concerned the concept of presumption and whether presumptions could be relied upon in the absence of medical research establishing a relationship between the vaccine and the disorder. And in his opinion, Advocate General Bobek stressed the difference between the English concept of presumption and the French présomption, arguing that under French law, it was a way of inferring one fact from another that was already proven. And in its judgment, the court again held that the standard of proof required is to be determined at a national level. Each member state can thus determine the standard itself as long as it is in line with the EU principles of effectiveness and equivalence. So the court green-lighted the use of this rather far-reaching presumption of causation in French court practice, as long as it did not amount to a full-fledged reversal of the burden of proof, which would have infringed Article 4 of the directive. And the influence of both Boston Scientific and Sanofi rulings on the evolution of European product liability law is evident in Article 9 of the new of the proposal for a new directive. In fact, the provision allows national courts to base the existence of defectiveness and causation on rebuttable presumptions, as long as the claimant has provided sufficient evidence that the product contributed to the damage and it is likely that the product was defective. So in so doing, Article 9 clearly restates the court's approach to evidentiary rules in relation to defective medical products. The Kurt's decision, however, concerns some specific classes of medical products where the exclusion of presumptive evidence would have made impossible or excessively difficult for the victims to prove the elements of the cause of action. And in a similar manner, Article 9, paragraph 4 of the proposal allows national courts to presume defectiveness or causation when the claimant faces excessive difficulties due to technical or scientific complexity. So the origin of this provision can also be traced back to the Kurt's case law. Moreover, the formal codification of these judge-made rules is particularly timely. For instance, the literature pointed out that evidentiary burdens seriously undermine the effectiveness of product liability law in relation to damage related to artificial intelligence systems. Therefore, building on the above-mentioned case law, Article 9 borrows national rules concerning defective medical products and extend them to any type of product of technical or scientific complexity, and this to the benefit of every consumer. Nevertheless, in conclusion, the evolution of consumer policy in the last decade questions the need for confirming the maximum harmonization character of the EU product liability regime, as it is clarified in Article 3 of the proposal, which clearly states that member states shall not maintain or introduce in their national law provisions diverging from those laid down in this directive, including more or less stringent provision to achieve a different level of consumer protection. Well, this provision is in line with the consistent case law of the Court of Justice, which stresses the complete harmonization goal of the Product Liability Directive. It's questionable whether the unity of the common market should remain the primary objective of EU product liability law, even to the detriment of consumer protection. Indeed, at the time when the directive of 1985 was adopted, and was discussed, consumer protection did not explicitly fall within the community's legislative competence. And in the absence of a clear constitutional basis for consumer protection, the best option, if not the only, for introducing liability rules for defective products was through market integration initiatives. And therefore, the directive was presented in its first recital as a necessary measure to equalize competition that would have been hindered by the lack of uniformity regarding the liability of producers. And in the cases delivered in 2002, the Court of Justice supported the interpretation of the directive as an instrument of maximum harmonization, thereby precluding national legislators the power to provide consumers with greater protection. But it is interesting to note that in its argumentation, the court put much emphasis on the struggle that marked both the legislative path leading to the adoption of the directive and the following process of transposition in national law. In fact, 9 years passed from the presentation of the first Commission proposal in 1976 to reach a final agreement within the Council of Ministers. And at the time the directive was adopted, part of its pro-consumer spirit was lost. And this becomes evident from a textual comparison. Under Article 1 of the proposal, the producer incurred liability for a defective product even if the article could not have been regarded as defective in the light of the scientific and technological development at the time when he put the article into circulation. As all of us know, now, on the contrary, the final text has a development risk defense for the manufacturer. And this was the result of a 6 years political stalemate within the Council of Ministers. And clearly, the defense in question represents a complete overturning of the pro-consumer impetus that characterized the original proposal. And even in the following 10 years from its adoption, the European Commission used the infringement procedure to force member states to correctly implement the product liability directives, as many were reluctant to implement a liability regime considered less favorable to consumers. So in light of all this, and I'm concluding, it seems that after almost 30 years of endless debates and problems in implementation, the Charter of Luxembourg was decided to ensure the uniform application at all costs, even at the detriment of consumer protection, because maximum harmonizations at the time was considered the only way to maintain the equilibrium laid down by the directive. But it is questionable whether the differences among the European jurisdiction may have distorting effects of such magnitude to justify the full harmonization, even at the detriment of consumer protection. And this is proven by the existence of divergent approaches by national courts on vital aspects of product liability claims, such as the standard of evidence proved by the case law of the Court of Justice. And this experimentalism by member state may also become part of the consumer law acquis, as proved by Article 8 and 9. So in conclusion, the proposal may also represent a missed opportunity for departing from this court's long-standing approach, or at least a missed opportunity for rethinking the role of product liability in the context of European consumer law of the new century. Thank you.
Thank you very much, Mr. Ruzzi, for this very informative presentation, which led us to throughout the developments regarding this topic. And now I would like to give the floor to Francesca Gennari from the University of Bologna. She's a doctoral researcher in the Law, Science and Technology Joint Doctorate Rights of Internet of Everything, funded by the Marie Curie Action, a joint action between the University of Bologna, Turin, and Vilnius. And she studied in Trento and Paris 13 and obtained an LLM in EU law in Bruges at College of Europe. And her doctoral thesis focuses on the Internet of Things, legal liability of connected devices in the home. So I'm glad to give her the floor, and the topic will be A Tale of Two Cities, ? Fennia against Philips, and Article 7 of the Product Liability Directive update. A challenging topic. Francesca, you have the floor.
Thank you, Professor De Franceschi. Thank you, Edoardo, for the interesting presentation, and thank to all the people who made it possible to organize this very interesting conference. I will try now to share my screen, as I have as well some slides. Okay. Just tell me if you can see full screen.
Yes, perfectly. Thank you.
Okay, so today I would love to talk to you about some of the most recent development in the Product Liability Directive field. First of all, I would love to focus on the judgment Fennia versus Philips, which is a kind of a recent one. It was just published last July. And then I wanted to highlight the possible tensions there can be with the proposed Article 7 of the Product Liability Directive update, which I will call PLDU for short, as in fact it is a quite a recent document, and the common ground among this judgment and the article, it's actually the identity of the producer. So before delving into the presentation, I would just like to outline what my reasoning would be. So after a few introductory remarks, I will just focus on the present, in particular on Article 3 of the Product Liability Directive, PLD, which is the one which identifies who the producer is, and briefly outline some of the most important case law concerning it. Analyzing this case law will allow me to describe the core of this presentation, which is this judgment, Fennia versus Philips, and why it is relevant for the identity of the producer, let's say case law litigation, but also legal interpretation. And then I will briefly outline the history and the models of the new Article 7 of PLDU, by keeping also in mind that we are really at the beginning of the European legislative procedure, and things might change when it is approved, the final text. And finally, after having outlined the tensions that there might be between the outcome of the judgment and the structure of Article 7, I will try to illustrate to you my very early initial thoughts on ways to reconciling. We can also discuss whether reconciling is the right word, the judgment and the article. So before delving really into the case law, I wanted just to outline an example. On the on the left side, sorry, of this slide, you can see a kind of antiquated old house, and on the other side you can see instead the house where you might actually live in. What is the difference? That in our home now there are several interconnected objects. Some are just let's say upgraded version of already traditional consumer objects, such as smart fridges or smart TVs, but others are completely new. For instance, integrated voice speakers or also cleaning robots. And they are possible because of the IoT technology, which functions more or less like this. We as humans give some inputs, such as vocal commands, or like we use our biometric data, for instance, our fingerprint to open like a screen. And then this is transformed in digital data sent through to the cloud through a gateway. And there is a lot of data processing, sometimes very difficult to understand what happens in there. And the reaction is sent back through the same route, but of course in the opposite direction. And the results could be the automation of the objects, or for instance, a communication with the different objects, for instance, the TV with the smart speakers. But here we can see that a lot of people are involved, even at the level of the producer of this object. And this is the real point. Who is the producer is a thing that is connected to the allocation of liability. Is it a new problem? No, because the old directive was made also because of this problem. At that moment, even during a mass production era, consumer objects were considered complex. But I argue that the level of complexity that we have reached today in the supply and value chain for consumer objects is really at another level of complexity, and therefore needs to be addressed. But what about the legal instruments that we have now to address this complexity? We only have product liability for the Product Liability Directive, Article 3, in order to understand who the producer is. And the first paragraph outlines that the producer coincides with the manufacturer of a finished product, or whoever like puts a distinctive sign on it. And then the article follows a cascade structure, especially highlighted in paragraph 3, where the supplier is assimilated to the producer whenever the identity of the producer cannot be known to the consumer within a reasonable time. This, of course, is a very general expression, and we will discuss later on its importance. I want to deal with the whole debate concerning the rationale about the harmonization versus the consumer protection, one that underpins the discussion on the Product Liability Directive, because already Edoardo made such a good work in explaining it. Just I wanted to point out that in the end, also nowadays, there is the harmonization as the main rationale of the Product Liability Directive, and that has a very deep root, because it was the outcome of a compromise, and this was already outlined by AG Tesauro in the first ever judgment on the PLD, and especially by AG Gilhud, who was the, let's say, theoretical protagonist of the maximum harmonization doctrine that was later adopted by the court. But we do not have to forget that also another AG and legal such as late AG Bott in Boston Medicine Technique instead suggested another way to interpret the Product Liability Directive as a consumer protection instrument. And in fact, the subsequent case law that interest Article 3 could be divided into two groups. The first group actually concerned the contrast of the Court of Justice and the Commission with some of the national legal tradition, which were actually more protective towards consumer. For instance, the French legal tradition had elaborated this Garantie de la Vente system, for which a consumer could actually ask the supplier to be compensated for the damage of the objects, and then the supplier could actually have a regress action and the action direct towards the manufacturer, the producer. And the same thing was happening in Denmark, and it was the result of judge-made tort law. And you can see there is just one preliminary reference procedure from Denmark concerning the interpretation of Article 3.3 concerning the supplier. And then there are infringement procedures by the Commission towards Denmark and France. And in the end, also these countries had to change their national law and introduce like a more compatible Article 3, paragraph 3 translation. But the second group of judgments does not really concern Article 3 directly. It's a series of cases which start to outline the complex value and product chains of some products, such as vaccines. And in particular, the identity of the producer here was functional in order to apply, of course, the main rule of Article 4, but especially Article 11, which establishes the starting point of the liability, on how to count liability for the producer. In this case, there was the alleged effectiveness of these vaccines, and these products had actually caused serious physical injuries, and complainants plaintiffs actually risked being time barred. And that was a kind of a surprise that the same AG Gilhud that actually was in favor of the maximum harmonization theory. Here he was more favorable towards the consumer, and instead in introduced this notion of the group sphere of control, in particular, especially where there was a complex industrial organization, such in the vaccines case. He argued that whenever the product exited like the sphere of control, for instance, the distributor of the main group, then from that moment you had to start counting in order to apply Article 11. And the same happened in Aventis Pasteur France, and A.G. Tristeniak built on the previous definition of sphere of control by introducing the notion of functional producer and multi-layered producer. So, what happened in the Fenia versus Philips case? It is important because it's actually a judgment concerning the interpretation of the first paragraph of Article 3, meaning who is the producer and how to behave whenever there is someone behaving like the producer. What does the consumer need to do? I will sum up here the facts of the case. A Finnish consumer had bought a coffee maker which bore the signs Saeco and Philips. Both on the trademark. The trademark was also on the package and on the machine. And the day after, the machine exploded. We don't know if it was a smart coffee machine, and their whole apartment caught fire. So Fenia, which is actually a house insurance policy, subrogated itself in the rights of the consumer and asked Philips to pay a considerable sum of money, but Philips refuses and said, well, I did not produce this object because Saeco, my subsidiary in Romania, is actually the manufacturer. It put its logos, and also there is a sign with written "Made in Romania" on the coffee maker. So it's the producer, and the consumer should ask Saeco and not to Philips. But then the court, with a kind of concise reasoning, actually reached an outcome that is favorable to the consumer. In fact, the court stated that whoever puts its own distinctive sign on a product must bear the responsibilities of being mistaken for the real producer. And this is apparent from a reading of both Article 3 and Article 5 of the actual Product Liability Directive. Article 5 concerns the, let's say, solidarity among different producers. Also, it takes on an historical interpretative approach by citing the Memorandum of 1976 and stating that the protection of the consumer would be insufficient if the distributor could refer the consumer to the producer who might not be known to the consumer, which was the completely different outcome of the previous group of cases that I mentioned. And finally, and this I think is the most important paragraph, the court states that whatever division of liability there might be among Philips and Saeco, well, the consumer must ask whoever appears to be the producer. And then it is, I think, up to national law to regulate the relationships between the different producers or like subjects within the same production chain. This leads us to analyze the proposed Article 7 of the PLDU. It was the whole proposal was presented last 28th of September, and it is an article that not only is rooted in case law but also on legal August Eli draft of a revised Product Liability Directive. What does this mean? The first part of the article is quite similar to Article 3. In fact, there is a wide notion of producer in the new proposed directive. The term manufacturer is used, replacing a producer, maybe in order to harmonize it with other legislative acts such as the medical devices regulation. But then, starting from paragraph 3, there is another cascade system that is structured slightly differently. It is stated that whenever the producer, the manufacturer, is not established within the union, the importer and also the authorized representative might be held liable at its place, as well as the fulfillment service provider. Also, this Article 7 concerns the refurbishing companies, because in paragraph 5 you see that whoever modifies the product thoroughly is liable as the producer. But then there is a change in paragraph 6 and 7. In paragraph 6, it is stated that the distributor has 1 month in order to allow the consumer to know the identity of the manufacturer. And this is an improvement compared to the previous text of Article 3, paragraph 3, which just mentioned the reasonable time. And then here, I don't know if you can see it, but paragraph 7 is in a way revolutionary, because it also makes the online platforms liable, provided that they respect the exceptions laid out at the Article 6, paragraph 3 of the recently approved Digital Services Act, so for hosting services. What are the first comments on this new article? Well, there is, I think, some similarity with Article 3, but it also has the benefit of including new but now common actors in the products and value chain. The only thing that I was worrying about was that the majority of for instance, smart good producers or manufacturers could be located outside the EU, and this would shift the balance of liability on importers, distributors, and all the other subjects that might have their main establishment in the EU. But also, I think that at a more deep level, there is a shift. If in the Product Liability Directive, Article 1 and Article 3 are all about the producer, which is thought of as one single entity, the things have changed for the proposed new Product Liability Directive, because both in Article 1 and in Article 7, the title of this article concerned the liability of economic operators, which is the group of all these new subjects. So on the one hand, the Court of Justice outcome in Fenia might empower, on the one hand, the consumer to ask for compensation whenever that is the case, according to the other rules of the PLDU, to whoever appears to be the consumer, provided that he put some distinctive sign, or also the average consumer might not know what the distinctive sign is. And on the other hand, Article 7 instead tries to create a balance among all the different actors involved in the production also of smart goods, and not only of normal consumer goods. But I think that first we have to remember, as told before, that the Product Liability Directive update is still at the very beginning of the legislative procedure, and we do not know for sure that the text of Article 7 will stay the same. Secondly, the interpretation of the Court of Justice in Fenia about the identity of the producer might work in favor of a better enforcement of the future Article 7. I explain myself. If the Court of Justice stated that whoever appears to be the producer bears the responsibility of also the liability that this entail, then all the people involved in the production chain will be very clear in highlighting who the producer is. And in this way, the future application of Article 7 will actually be much smoother. So in order to conclude, Article 7 is an article that is rooted both in case law and in legal scholarship theories, so it comes from a long process. It has the merit of introducing a list, an ordinated list of subjects that are involved now in now mainstream smart good production value chains, and the slightly more consumer favorable CGU judgment, Fenia versus Philips, might actually help in Article 7 future implementation. So here's some references, and I really thank you for your attention, and I'm really looking forward for your feedback and question. Thank you very much.
Thank you very much, Francesca, for another very interesting presentation, which complements perfectly Eduardo's presentation. So a lot of food for thoughts, looking at the developments and at all aspects we are just still not regulated and not properly addressed by these developments. So now I would like to open the floor for a discussion, and as usual you can raise your virtual hand or write in the chat. I'd like to make some remarks or questions. I imagine you're all very tired and you're hoping we close the session as soon as possible, but if you would like to join. Now we have Emilia, please. Emilia, you're welcome.
Sorry, my network is quite bad, so I will stay without camera. I hope you can hear me.
Yes, perfectly. Thank you.
Yes. Okay, I just have a general question. I already started to write over LinkedIn to Francesca because I found her presentation excellent indeed. And just a general sort of a point of your view on the matter when it comes to the new proposal of the new product liability regime. Do you think, but really in general, what is your opinion, if it will improve or for the better, or it will, as I heard your comments, I hear your sarcasm that it might also, when it comes to some aspects, stay as it is. So what do you think, whether there would be improvement when it comes to these changes that of course follow digitalization and development? Thank you so much.
Thank you, Emilia, for your kind words and your question. Well, actually, it's still everything is changing so fast, so it is difficult also to have a fixed idea on a text that is bound also to be changed now in the legislative procedure. I think that this draft, this proposal has many merits in a way, like it introduced a lot of new subjects that were not considered before, and especially as far as the fixed requirement, for instance, for the distributor, which is not called supplier anymore, to tell the identity of the future manufacturer, now producer, to the consumer, I think it's an improvement because people really were time barred. And also, I think that the points that actually Edoardo examined are really the innovative and more and most interesting also part of the product liability directive update, because they have also a procedural aspect, which is kind of odd because it used to be like just a substantial law directive, and now it is enriched with this further element. And I think that despite the fact that it's still a maximum harmonization instrument, I think that it will not just be maximum harmonization concerning the substantive rules, but it will start also a process of harmonization of procedural law, which we have heard before in the previous panels, is now still very national, and I think this will be very interesting. Also, I think that in any case, whatever text there will be, if there is no introduction of any economic threshold for the let's say the demonstration of damage element, it will be a much more litigated instrument than it used to be, because also this is already clear to the Commission, because I think one of the last articles, I think Article 15, introduces also the possibility for the Commission to create a database in which national courts and judges will have to insert the cases that they are solving with the future product liability directive. And this, I think, it's something that is done also because it is foreseen that it will be litigated much more. Given the fact that the previous instrument was there for more than 35 years, it's well integrated now in all the national members of the EU, even if some were very reluctant at first to introduce it as it was, because they were more consumer protective than others. And I think that in any case, overall, it is a good proposal, but it really, the only real criticality that I see is that despite the fact that the cascade system is well structured, it must take into account also the factual situation that the EU is maybe the first to regulate technology, but it's not the first ones yet to produce it. And so most of producers might be outside of Europe, and in this way just can not be addressees of this proposal that was actually targeted for them. And that is my first impression on it, but I'm open to discuss it more with you if you'd like.
Thank you very much for your excellent explanation. I just wonder also with respect to your presentation and Eduardo's, what happens when it comes to the rules related to the burden of proof, the causal link, and that is also something that is quite intriguing. So if some of the speakers could comment on that, and that's it for me. Thank you. Sorry for taking your. Thank you.
No problem, but maybe Eduardo wants to speak about it, given the fact that he presented them before. But I will also give my comments after him.
Thank you. Well, I believe that the introduction of Article 8 and 9 will surely have a positive impact on how product liability claims in complex cases will be litigated. It will surely share in a more fairly manner the burden of proof between the injured person and the economic operators. And this, of course, will increase the chances of enforcing successful compensation. And the burden of proof has always represented one of the major issue of for the success of the European product liability regime. So I am quite I'm quite glad of the codification of the Court of Justice judge-made rules on this aspect. Francesca, if you want to add your comment.
Yeah, for sure. The case law was very important, and especially Novo Nordisk Pharma that you cited. But also, I wanted to point it out that even like at a different level from a legal scholarship point of view, already in 2019, where the expert group on liability of AI and new technologies had elaborated this kind of framework, procedural rules. Especially, I think Professor Pagallo was the mind behind the right to log in, which is basically what Article 8 and 9 will be about, meaning giving access to how the algorithm works. I think that in principle, like it will all the success of these two dispositions will reside in any case on the implementation at the national level, because there are counterposing also interest, because of course a producer, whenever it will go to court, has also intellectual property to defend, and there must be some harmonization also in a way that the discovery is made, because we cannot allow that one state is more severe and other are more lax on it, because then there will be, I think there will be many cases of forum shopping, even though like on a general basis, it should be the consumer. The consumer can choose actually to start the proceeding in its own jurisdiction, so should be a bit more favored. Yes, I think that these rules, in any case, are bound to be implemented and be discussed at more. Because also the proposal on the extra contractual liability of AI at basically twin articles, Article 3 and Article 4. They concern different aspects, but they function more or less in the same way, and we will see whether the basis of the harmonization could be stretched further in order to also include procedural rules, without the member state making a fuss over it, because of course it impacts their judicial systems.
Thank you very much for question and answers. We have another question by Cemre. Please, you have the floor.
Hi, good evening, everyone. And thank you for both of the presentations that were excellent and very elaborated. I have two questions. I would like to address my first question to Francesca Gennari, if I pronounce it correctly. And I would like to address the second question to both of the speakers, whoever would like to answer. My first question is related with the product liability of the online platforms. As long as there is someone in the global chain that is located in EU, online platforms wouldn't be liable. But considering the scale of economics that online platforms enjoy, do you think it is fair that online platforms are subject to only a kind of subsidiary liability. Do you think that online platforms should have been counted as one of the liable, like primarily liable actors in the global value chain? And my second question is something more general. Today, I just gave a conference about the PLD proposal, and I was talking about that many of the differences are actually not new at all. As far as I understand, the differences between the PLD and the PLD proposal, like some of them are those that have already been accepted in the literature or in the case law, and some of them are relatively new, such as the moment in time that we look for defectiveness that has been enlarged, I think, considering the evolving nature of the autonomous systems. But this kind of interpretation has already been made and supported in the literature under the existing PLD as well, for example, by Hagen, by Wagner, etc. And do you think that there is a really novel part of the PLD proposal that takes the things further than the PLD in a let's say substantial way? And this was my second question that you can both answer if you like, of course. Thank you.
Okay, so first, thank you for your question. Maybe I can share again the screen because I can show you the text of Article 7 better that I had on my slide. 1 second. Okay. Here. Voila. Here it is. Sorry. Here. I don't know if you can see it quite well, but I think that online platforms can be liable because you have also to take into consideration that I think one of the revolutionary things of this proposal is that it considers software, not only integrated software but also standalone. As product. So this seventh paragraph, I think it's mainly done for them, and in any case there is a connection with the Data Services Act because Article 7 here makes it explicit that the online platform is not, sorry, it just skipped. It must not be a distributor or the producer of the product, so it can be liable. Also, it is true that, for instance, the main platforms that exist and operate in Europe have authorized representatives, but also their seat in Europe. So I don't think that they will be entirely exempt from liability. It is a delicate balance because the digital policy, it's a kind of a puzzle that needs to integrate together, for instance, the Digital Markets Act, the Digital Services Act, and the product liability. I think it is a success that online platform actually were inserted in the proposal. I don't know if it will arrive at the end of the legislative procedure. Hopefully so. And but if you look at the framing, I'm sorry that it was not clear from the text before. Paragraph 7 of Article 7 of the Product Liability Directive update also makes this kind of connection to Article 6 of the Digital Services Act and to its paragraph 3 that says that the exemptions of liability do not apply. So in a way that it's a complex mechanism, but at least the two legislative instruments speak to each other. So I think compared to other cases, this is already an improvement. As far as the more general question concerning the elaboration of legal theory and case law, I think, yes, I agree with you. Most of the elements that were introduced and that we both, Edoardo and I, outlined in our presentation were things that were known. But you have also to remember that this was not, the fact that it has been done in an harmonized way, like this final first product of the proposal, it's not something that is a given, because in order to update the product liability directive, first there was just a dedicated group for that was responsible for basically selecting all the relevant case law that was applicable to it, and try to find a way to integrate the future text. And on the other hand, there was the formation concerning AI and new technology, and there were two different groups, and somehow I think at the policy level they merged these things together, but for my reading, at least at this level, it reads quite well. It seems well integrated, also because if we were like in a common law country, maybe this would have not been necessary, because we rely on precedent. We would rely on precedent, and so it wouldn't make any sense to make something that is updated. It is true that the Court of Justice has a considerable influence, but after 30 years, I think that it was time. There was a corpus of judgments that made sense combined all together, even if judgments come and go, and they are the fruit of like a single case. So it's not something that you can foresee in advance. You can say, oh, first there is Medicina Asturiana, and then we will have Sanofi Aventis or Aubern. But this is my view. I let also Edoardo comment on that.
Well, I think that the most critical aspects of the new product liability directive does not regard the restatement of the Court of Justice case law, but rather some innovative elements of the new liability regime, such, for instance, we'll say the inclusion of digital manufacturing files within the notion of content. Because in the context of 3D printing, we have different relations between the actors who are involved in the industry. We can say that there is no consumer in the context of 3D printing or a producer. There are actors who create digital content, share it through platform, actors who receive this digital content and print it. And it is difficult to frame these actors within the categories of product liability law. And I think that it will create difficulties in the application, because usually the creator of a digital manufacturing file is an hobbyist. So it has not the structure and the economic resources to compensate in case of an injury, but also the person who prints the digital manufacturing file, differently from the traditional consumer, has the possibility to inspect the product. He has the technical knowledge, because the user of 3D printers are usually person with a technical background. He has the technical knowledge to inspect the product and looking for defects. And as you can imagine, this is a completely different category from the one of the consumer, of the bystander, that was at the center of the American strict product liability case law in the 60s. So I think that the directive will have a positive impact on the aspect that have been already enshrined, that have been already discussed by the Court of Justice and the doctrines developed by national courts and ratified by the Court of Justice. But on this new aspect, there are some criticalities, there are some flaws that needs further discussion.
Thank you very much to both of you. But I would like to just briefly clarify that I didn't say that online platforms are exempt from liability, but I also see the PLD proposal, but as far as I see, it is not an unconditional one, but it is an conditional liability. That was the part that, that was the part that I would like to ask, because even if the victim identifies, or even if there is a liable, even if there is a liable actor located in the union, the victim can still want to see online platform, and I find it fair because of the large scale of economics. I would, for example, as a victim, let's say, I wouldn't want to struggle with getting compensation from a small producer. Maybe he or it is insolvent, etc. Sorry, everyone calling me from. Sorry for the noises. And that was the I would like to ask. It is not a re-question. But I just would like to clarify that I didn't say that they are exempt from liability, but it is kind of a condition. Sorry for, I hope you didn't hear all the phone calls, etc. Thanks again.
Thanks you for your clarification. Now I understand it more. But yeah, sometimes even if we know that we have, here I do play the advocate of the devil, right? Sometimes we acquire the product through, most of the times, platforms, but the product is not good quality, or it creates damage to us. And I don't think that consumers would sue the platform, or generally they would sue the manufacturer. Maybe they don't know who it will be. So I think that also with the case Fenia versus Philips, I think that they will find much easier who the producer is than it used to be.
Thank you very much for the fruitful discussion. Any other questions? Remarks? So from my side, just to stress the circumstance that this has to be considered a step forward. But if we see the codification of some acquisitions, like the qualification of software as a product, there is still quite a lot of uncertainty regarding for instance, the liability for the software developer, or the requisites in order to qualify a digital system as a defective, or again the opportunity to extend liability to other actors different from the manufacturer. For instance, trainers of self-learning systems or data suppliers. These are, in my opinion, still questions which still need to be nearly clarified at legislative level. I wonder whether you have some remarks on that, brief remarks, or whether you would like to conclude the session, that we go towards conclusion, but you have still the opportunity to take position on this remark.
Yes, I agree with you, Professor De Franceschi. There are still some aspects that need clarification, especially as far as the subjects that are involved. Of course, I think that the proposed Article 7, it's a object of a compromise. But if I looked also, and in fact, the software developer is not mentioned, whereas it was present in other discussions of the European Parliament about the front end and the back end operator, and as well in the expert group on liability of AI and new technology. I hope that someone will address this thing during the legislative procedure. We'll see. I think that I think that there might be some political emphasis in making software developers, like as the single person, liable for such for things that could actually cause damage to quite a lot of people. Like really, we're talking about thousands. There was. I think that it's in the US. Professor Choi has been trying to adapt the so-called crash-worthy liability theory, which was applied in products liability cases for cars, also to technology. And I think Eduardo was making reference to it maybe before. I think that the approach of the Commission was maybe along the line of this scholar, which stated basically that code is gonna crash no matter what, even if one puts the highest degree of diligence in creating it. So we have to find the ways in order to, let's say, make the damage smaller, or in any case more easily compensatable. So I think that this kind of process is bound to happen also in Europe for sure. Like there must be a minimum threshold of accuracy that is being done, and I think that this process is being addressed currently on all the discussion concerning standardization of the AI, and that in the end we will have to unite all the pieces of these different policies that are bound to communicate with each other, even if it will be difficult.
Thank you very much. Eduardo, if you would like to make the very last brief statement, or if you are satisfied, no problem.
Yes, sir. I agree with both you and Francesca's impressions, and I believe that will be important to again balance the conflicting interests between consumers and market operators. But in this case, we should also consider the gap between the European AI industry with the American and the Chinese one. And in this sense, we also have to elaborate a system that does not hamper research and innovation in this field. Otherwise, the gap between these two tech giants, at least in this field, will be insurmountable. But on the contrary, on other fields, before I mentioned additive manufacturing, I think that there is a need to further research on the status of the market. In the context of additive manufacturing, as I said, we are facing a primordial development of this industry, and imposing such a rigid liability framework will have on the contrary, the effect of probably killing further activity, at least at the European level, regarding digital designers or platforms sharing digital manufacturing files. So I think that maybe one directive cannot fill all digital technologies, at least cannot fill well-developed markets of such as smart objects markets or AI systems markets, and areas where we are still at the infancy of an European industry.
Thank you very much. Thank you again for these two brilliant presentations and for the thoughtful discussion. I would like to thank each excellent speaker of 2 days, first part of the conference, and I would like to invite you to join us tomorrow for our second part of the conference. We will start at 8:30 Central European Time with two sessions actually on consumer and market protection in the digital age. We will have a session on country reports. Then we will focus on competition law and consumer matters and the challenge of energy markets. And then we will come to one of the most debated issues today, and actually to the public enforcement and procedural issues in consumer protection. So we are, in the name of my co-editors, or my fellow editors, I am really thankful for your excellent contributions today, both from the side of speakers and from those who took part in the discussion. And I would like to invite you to join us tomorrow, and wishing you a good evening, and thank you again.